What if I told you that centuries before modern Europe built its legal systems, African kingdoms already had constitutions, courts, trade laws, women judges, and protections for citizens? What if the world's history books left out an entire legal civilization? Tonight, we uncover the lost laws of Africa. These were not tribal customs whispered around campfires. They were organized systems that governed empires stretching across deserts, rainforests, and coastlines. Merchants signed contracts in Timbuktu. Disputes were settled in royal courts in Benin. Ethiopia enforced written legal codes while much of Europe was still fragmented by feudal wars. But then came conquest, colonization, and a rewriting of history. Why were these laws erased? What did they actually say? And how did they shape Africa's greatest empires? Stay with me, because by the end of this video, you'll see African history in a way most people never have before. To understand Africa's lost laws, we must travel back long before colonial borders existed. Africa was home to powerful states and empires with sophisticated political systems. The Kingdom of Kush, the Empire of Mali, the Kingdom of Benin, Great Zimbabwe, and the Ethiopian Empire all developed systems of governance rooted in law, diplomacy, and accountability. In Mali, the famous Kurukan Fuga Charter, established after the victory of Sundiata Keita in the 13th century, outlined rules for governance, social responsibility, and human rights. Some historians consider it one of the earliest constitutional charters in the world. It declared protections for individuals, rules for resolving disputes, and responsibilities between rulers and citizens. It even addressed the treatment of slaves and the protection of vulnerable people, centuries before many European nations debated similar ideas. Meanwhile, in Ethiopia, written legal traditions evolved through texts like the Fetha Negast, a comprehensive legal code used for centuries in courts and governance. It blended civil, criminal, and religious law into a structured legal system. These were not isolated examples. Across Africa, law was deeply connected to community, justice, and balance. One of the most remarkable legal systems emerged in the Kingdom of Benin, in present-day Nigeria. Benin was famous for its bronze art, towering walls, and powerful obus. But beyond its beauty was a disciplined state with an organized judiciary. The Oba was the supreme authority, but justice was not arbitrary. Cases were heard in royal courts, evidence was presented, and officials known as Uzama and palace chiefs played key roles in governance and dispute resolution. European visitors in the 15th and 16th centuries described Benin as orderly, clean, and highly organized. Contracts, taxation, land rights, and trade regulations were enforced through established institutions. Benin's laws also protected trade routes and market systems. Merchants who violated agreements could face fines, confiscation, or exclusion from commerce. In a kingdom connected to international trade with Portugal and other regions, commercial law mattered enormously. And here's what's often ignored. African legal systems were not frozen in time. They adapted. They negotiated treaties. They managed international trade. They evolved. Now we move north to the legendary city of Timbuktu. In the 14th and 15th centuries, Timbuktu was one of the world's greatest centers of learning. Its universities and libraries attracted scholars from across Africa and the Islamic world. But Timbuktu was not only about knowledge. It was also a city governed by law. Islamic jurisprudence formed the backbone of its legal system, but local customs were integrated into court practices. Judges, known as qadis, settled disputes involving trade, marriage, inheritance, and criminal matters. Caravan merchants crossing the Sahara relied on enforceable contracts and legal protections. Without law, the gold, salt, and manuscript trade could not have flourished. Imagine a city in the African desert where scholars debated legal philosophy while merchants signed commercial agreements from thousands of miles away. That was Timbuktu. And yet, many modern narratives reduce pre-colonial Africa to chaos and disorder. The evidence says otherwise. If this history is opening your eyes, take a second right now to subscribe, share this video, and turn on the notification bell. These forgotten African stories deserve to be seen by millions, and your support helps bring them back into the light. Another myth about African legal systems is that they excluded women entirely. The reality was far more complex. In many African societies, women held significant legal and political authority. Among the Akan of present-day Ghana, queen mothers played major roles in governance and succession. In parts of East and Central Africa, women could inherit property, lead clans, and participate in dispute resolution. Community justice was also central to many African systems. Instead of focusing only on punishment, courts often aimed to restore harmony between families and communities. Compensation, mediation, and reconciliation were common practices. This did not mean African societies were perfect. They had inequalities, conflicts, and harsh punishments at times. But they were functioning legal cultures with their own philosophies of justice. One of the most important ideas was that law belonged to the community, not just the ruler. Elders, councils, religious leaders, and local courts all participated in maintaining order. So what happened to these legal systems? The answer lies in conquest and colonization. From the late 19th century onward, European powers carved Africa into colonies during the Berlin Conference of 1884 to 1885. Colonial administrations imposed European legal systems and often dismissed African laws as primitive or uncivilized. Traditional courts were weakened, local authorities were subordinated, and written colonial codes replaced indigenous systems. In some places, customary law survived in limited form, but it was often reshaped to serve colonial interests. This was not just political domination, it was intellectual domination too. By controlling schools, courts, and historical narratives, colonial powers created the impression that law and civilization arrived in Africa from Europe. Generations grew up learning foreign legal traditions while their own were ignored or forgotten. Yet the old systems never disappeared completely. Elements of customary law still influence legal systems across Africa today, especially in matters of marriage, land, inheritance, and community governance. The lost laws were buried, not destroyed. Today, across Africa, scholars, historians, and legal thinkers are re-examining these forgotten traditions. Why? Because history shapes identity. When a people are told they had no systems, no institutions, and no laws, it affects how they see themselves and how the world sees them. Recovering Africa's legal history is not about romanticizing the past. It is about accuracy. The truth is that African civilizations built complex systems of governance long before colonialism. They debated justice, protected trade, managed empires, and created legal traditions that deserve a place in world history. The lost laws of Africa remind us that civilization has never belonged to one continent alone. If this story changed the way you see African history, don't let it end here. Subscribe, share this video, and turn on the notification bell so you never miss our next deep dive into the hidden history of Africa. And if you enjoyed this documentary, watch our next video. History was never lost. It was hidden. And together, we're bringing it back.